Hello everyone, my name is Matias Gonzalez. I'm an attorney in New York City and a bar exam instructor, and today I'm going to show you how to get all of your evidence multiple choice questions right using our comprehensive flowchart. Check it out. So today I'm going to show you how to use this chart to answer this multiple choice evidence question, the test hearsay. Our flowchart does three important things. It helps you learn the federal rules of evidence. It helps you understand when the rules are and are not triggered by a fact pattern. And lastly, it helps you memorize rules. As you can see, our chart begins with the most important rule of evidence, which is relevance, and then it crests out to encompass all the other federal rules of evidence that are commonly tested in law school or on the bar exam. Because today we're only going to be covering a question that is about hearsay, we've omitted the other rules and pathways included in our flowchart. Also note that our flowchart is in PDF format and in nominal page sizing. This makes the chart easy to download so it's available anytime and easy to print on regular sized paper so you can make it part of your existing outlines. It's also coordinated so that if you wanted to, you could print out all the pages and turn it into a large poster to paste on your wall. Now let's take a look at the multiple choice question, and then we'll use this flowchart to answer it. Driver is being sued in civil court for his involvement in a car crash. At the time of the crash, driver was driving a red sports car that struck pedestrian at an intersection, causing significant injuries to pedestrian. Right before the crash, Walker was standing on the curb talking on the phone when he yelled, "Oh my God, the red car just ran the light." Immediately thereafter, the crash between driver and pedestrian occurred. At trial, pedestrian's attorney seeks to admit Walker's statement to prove driver's liability. Is the statement admissible? So now, that we have our question, let's use our chart to answer this question. The way to use this chart is by following the arrows from the top. Each time an arrow leads you to a question or rule, you apply it to the question's fact pattern. If the rule or question applies, you continue down that path. If it does not, you look to see if another arrow can lead you further along until you arrive at a relevant rule that makes the evidence admissible or inadmissible. Let's use our fact pattern to work through this question in our chart. So we always start with, is the evidence admissible? The first threshold question, as I mentioned, is relevance. Relevance is first, does it have any tendency to make a fact more or less probable? Here it's, does Walker saying, "Oh my God, that red car just ran the light," have any tendency to make it more or less probable that driver was at fault? Yes, it does. So once we've answered yes, we go down the corresponding arrow. Then we have another question that relates to relevance. Is it a fact of consequence? Meaning, is it going to matter if he ran the red light or not as to decide the civil lawsuit between driver and pedestrian? And the answer is yes, because it will tell us if driver was negligent or not. So we follow the yes arrow this way, and then we go on to the next threshold question, which is the probative value substantially outweighed by prejudice. Now the key operating word here is substantial, right? All evidence that's admissible against another party is going to be prejudicial to them. What you're looking to see is if the probative value is substantially outweighed by prejudice. Typically, that's only when you're showing pictures of injuries caused to a person that is a party to the lawsuit. But in this case, even though it is slightly prejudicial to the driver to say that he ran the red light, it still has enough probative value to help us decide the case. Therefore, is the probative value substantially outweighed by prejudice? The answer is no. So we keep working our way down. Now we're in this area where it's admissible subject to all the other evidence rules. So what we're going to help you work through is how to decide what rules are triggered and which ones are not. First, let's take a look at policy exclusions. The policy exclusions, as you can see here, are subsequent remedial measures. So let's just go quickly through them and eliminate what doesn't seem to apply. So does anything relating to what Walker said, oh my God, that red car just ran the red light, relate to a subsequent remedial measure? It does not. So we get rid of it. Is it about liability insurance? It is not. Is it offering to pay medical expenses? It is not either. So that doesn't apply. Is it a settlement offer or a negotiation? No, because Walker is just a witness. He's not even a party to the lawsuit, so he can't make an offer. Is it a plea bargain or plea negotiation? Don't forget that it's a civil suit and you only have plea negotiations in criminal proceedings. So now we can eliminate policy exclusions in that area of the chart because it's not applicable. We keep going. Now we proceed to privileges, which is the next item on the chart. Here we have spousal privileges, attorney-client, and doctor's privilege. Clearly, Walker is not anyone's doctor. He wasn't speaking to a doctor. He's not an attorney, and he's no one's spouse in this fact pattern. Therefore, we can eliminate all of our privileges section of the chart and keep going. Next, we're on to character evidence. Character evidence is, as it describes, evidence that is meant to show conformity therewith. Here, pedestrian's attorney seeks to admit is Walker's statement saying, oh my God, that red car just ran the red light. Therefore, we're not trying to admit anything relevant to driver's character. We're just trying to prove liability. Therefore, all aspects of character evidence are also going to be eliminated from contention. So we're not going to go down that path. Next, we have impeachment. Impeachment, the legal definition, is when you're trying to attack a witness's credibility. Here, all we know is that the pedestrian is trying to offer Walker's statement, which is, oh my God, that red car just ran that light, for the purpose of proving liability. In the closed world of our question, we have no idea if Walker will eventually be impeached, but he's certainly not being impeached by pedestrian's attorney because he's trying to prove that driver was liable. So all the questions and rules relating to impeachment can also be ruled out in our analysis. Next, we have perception and bias. Well, there's nothing that we're being told, again, in the closed universe of the question, that pedestrian's attorney is trying to call into question Walker's ability to see the car running the light. Now, we would assume that driver's attorney is going to try and call it into question under impeachment, but it's not before us here. Furthermore, bias isn't really part of this question either, because as far as we know, Walker just happens to be someone who was at the curb and saw the accident happen. He's not related to any of the parties, and there's no reason to, we don't know that he was ever a victim of a car accident, so there's nothing to tell us that perception or bias will be triggered. That lastly leaves us with hearsay. So what is the threshold issue in hearsay? So the first question that we have to ask ourselves is twofold. Is it, number one, an out-of-court statement? Well, we know from here that he was standing on the curb at the time and talking on the phone when he said, oh my God, that red car just ran the red light. So it was clearly not made inside a courtroom, so the first part is met, which is that is an out-of-court statement. Next, is it offered for the truth of the matter asserted? So what is the reason why pedestrian's attorney wants to admit this evidence? And the reason why is to show driver's liability, as it's shown here, to show driver's liability. So is it being offered for the truth of the matter asserted? Is it being offered to show that, yes, the red car did run the red light? Yes, it is. Therefore, Walker's statement is going to be hearsay. And what do we know about hearsay? It's inadmissible unless an exception or exemption applies, which means that the only way that we have to go is this way, under hearsay exemptions or exceptions. So we can eliminate this arrow coming out of hearsay. So first, let's go quickly through the hearsay exemptions and let's figure out if they apply to our fact pattern. Is this the admission of a party opponent? No, it's not. Walker's just a witness. He's not a party to the lawsuit. Is it a prior inconsistent statement or prior consistent statement? They're not, because as far as we know, in the closed universe of the question, Walker has not made any other statements other than this one. Is it a prior statement of identification? Well, some of you may say, well, he's identifying a car. Okay, fair enough. Let's go down that rule and see if it applies. Well, here it tells us that the declarant witness made a prior statement of identification of a person, which here he's identifying a car. So we can eliminate a prior statement of identification as a possible exemption because it does not apply either. So essentially all the hearsay exemptions are now omitted. So that leaves us with one arrow. So now let's go to admissible hearsay exceptions. Well, you see one arrow talks about when the declarant, meaning the person who made the statement, is unavailable. Here, there's nothing to tell us that Walker is not available. So therefore, we're just going to, at a minimum, scratch this off, but we might come back to it. But you can always live in the closed universe of the question. So you can assume that this is not going to be an issue. The next arrow takes us to the declarant unavailability is immaterial. Well, that seems to kind of go with what we have. So now we have an excited utterance. Well, what is a legal excited utterance? Well, let's read the rule statement. So it must be a statement. So a statement means it's communicating something, right? It's an assertive conduct of some sort. Well, here he's on the phone, right? And he yelled, "Oh my God, that red car just ran the light." So the statement part that is required for an excited utterance is met. Relating to a startling event or condition. Well, why did he yell, "Oh my God, that red car ran the light"? Because he presumably saw the car run the light just before a car crash occurred. So the second part is also met. Lastly, it's made while the declarant was under the stress of excitement that it caused. Okay, so why did he yell out, "Oh my God, that red car ran the light"? Because he was perceiving this. And usually, and you could annotate this in your outlines, anytime you see exclamation points, it's a good sign that someone is under stress or excitement. And so, and here the last knot to tie, so to speak, would be to say the excitement is caused by what he's seeing, therefore the third element is met. So we've reached a hearsay rule exception that could apply, because it says here admissible if a hearsay exception applies, right? And here we found one. So we've reached the end of the chart. There's nothing else for us to do after we found this. So now let's go back to the question and look at the answer choices. And we're going to look for an answer choice that talks about an excited utterance being the correct answer. So is the statement going to be admissible? Yes, it is. So we can immediately eliminate A and B because they start with the word no, and we're down to C and D. C says yes, because Walker's statement shows their then existing state of mind. Well, we didn't get to analyze state of mind here. All we know for now is that excited utterance does apply. A lot of times an out-of-court statement can come in under more than one exception, but let's just check it out and before we do any more work if excited utterance is an answer choice. So then D says yes, because Walker's statement was about a startling event and made while they were under the stress caused by that event. So you can see how answer choice D is essentially a restatement of our rules for excited utterance, elements 2 and 3 in the excited utterance. Therefore, D would be the correct answer to this question. And that is how you would use the chart to find the answer to your question. There you are, guys. We hope that our flow chart was helpful. And if you'd like more free content, don't forget to like and subscribe. And if you'd like a full version of our evidence chart, check it out on the link below.